Excellent. So thank you everyone for coming to this virtual Maryland Horse Council Business Networking Seminar. I see our speakers, our panelists, Kate, Andy, CR. Good morning, guys. Good morning, everybody else who's out there. Let me switch my view. So we've had a Maryland Horse Council business network for probably about 10 years now. And one of the wonderful benefits of the network is any of you know who have attended one of them in the past, is the ability to shake hands with people and look them in the eye and get to know them, our peers in the industry, in the horse industry, and to get to know other business owners, and to share our experiences. And sometimes it acts as a therapy group, and learn new resources and new contacts, business to business owner. This has been an exclusive benefit for business and farm members of the Horse Council. Because of COVID, we have opened this up to everyone, but we hope after we get through this COVID that you all will find value in these networking opportunities and that you all will join as business or farm members. Carrie?
Perfect. Thank you, Crystal. I am actually going to move to Corinne to go ahead and introduce our speakers. I'm going to go ahead and share our agenda at the moment, which you all should have received in advance yesterday evening.
Good morning, everyone. Thanks for making the time to join and to sign up and to join this morning for this exciting topic. I'm sure we'd all rather be on our horses this morning. But first up, we have Kate Masterton, and she is an attorney with a law degree from American University. I have the pleasure of working with her on the Maryland State Bar Agriculture Law section as well. And her bio is included in the agenda, and Kate also has a presentation with her contact information that will be forwarded to everyone after the presentations this morning. So if you have any follow-up that you would like to have with her on specific cases, you can work on that directly. So without further ado, and Kate, feel free to add anything to your background that you feel is important in terms of, couching this presentation as a horsewoman and a general practitioner in Maryland. Certainly plenty of experience in this area of law, okay? So, okay, well, whenever you're ready then.
Okay, good morning, everyone. Thank you for joining. Hello, especially to my clients. I see your names listed there. A number of questions have been posed by participants in advance of this presentation, and looking them over, it occurred to me that if you understand the concepts of legal negligence, you're going to be able to apply them in a wide array of circumstances. So instead of trying to respond to each individual question, I'm going to try to teach you how to fish instead of giving you the fish to eat. So the elements of a claim for negligence are the duty to use reasonable care, failure to conform to the required standards, causal connection between the failure and the injury, interests of another, and no contributory negligence by that other person. That's in Maryland. I do want to point out that Maryland is one of only 3 or 4 states that have the no contributory negligence as element. All of us are very fearful of negligence suits. That's a very good thing. That is not the case in Virginia, and none of my comments are intended for any jurisdiction other than Maryland. I'll also, this is the time to say that nothing that I tell today constitutes legal advice. It's legal information. I cannot give legal advice unless you're actually a client of mine. So, go on that proposition. So the duty to use reasonable care raises the question, what is reasonable? What is the standard of care? So at a minimum, the standard of care is to follow the law. And I've learned during COVID that a lot of people do not know what constitutes the law. They think that it's just statutes that are on the books. The law consists of statutes, ordinances at your local level, executive orders by the chief executive, whether it's the governor or the county executive or the head of the county council, administrative regulations, interpretive guidance. If you go on the governor's official webpage, you will see proclamation, executive orders, and interpretive guidance. And those kind of memoranda from the governor's office of legal counsel can be very helpful in understanding what an executive order actually means. And then there's case law, what judges have said. So all of that is the law. CDC policy, that's the law. OSHA and MOSH, Maryland Occupational Safety and Health regulations, Department of Agriculture regulations, that's all law. Follow the law and you can't go wrong as far as the standard of care goes. But it requires more than simply following the law. It requires following best practices. In every profession in business, there are certain established best practices. I mean, a good example of that is a horse in an aisle needs to be on cross ties. Not law, but that's best practice. And finally, follow common sense. And we all have that in great abundance if we're horse people. So let me give you an example of the practical application of these concepts.
Kate, let me just interrupt you for 1 minute. Since we're having issues getting your presentation up, just so you know, what I have done is I have posted your content in the chat group so folks can follow along, just letting you know that I've done that in the interim because we're having technical problems. Apologies for the interruption.
That's fine. That's fine. So a practical application for someone who's operating a boarding and lesson barn is that you owe a duty of care to your employees, to your students, and to anyone who is what lawyers call an invitee, whom you have allowed to almost come. You owe all of those. What does the law say as far as COVID? Well, the CDC guidelines say wear a mask. By the way, this is the time to mention, don't listen to press conferences. That's the law. I look to see the writing. So go to the CDC webpage and look at what the CDC guidelines actually say. Listen to the president telling you not to wear a mask. Believe it or not, the president is not the law. Yes.
Kate, one more.
Yes.
You're breaking up. So what I might suggest, maybe your internet connection is a little spotty this morning. I realize it's not ideal, but you might try to turn off your video, see if the sound comes through a little bit more clearly. Do you want to give that a try? And we'll see if you're a little bit less spotty.
Yes, the area of northern Baltimore County where I live has very poor internet service, so there's not anything I can do about it.
No, but try to turn off the video and see if the sound comes through better, and we apologize that you're a black box.
Sure. So
sorry.
The video is off. Can you still hear me? Is it any better?
Yes, I can hear you, and I think you're better. So go ahead.
Okay.
Apologies, and then maybe you, yes, thank you.
Sure, no problem. So one of the things that the law says is to wear masks. I know a lot of people think that's not the law, but yes, it is the law. So you should wear a mask, and you should require that everybody on your premises wears a mask. That's an example of following the law to demonstrate that you are meeting the standard of care. The other part of that is that you have to enforce what your rules are. It's not any use, and it's actually counterproductive to post a rule saying everyone must wear a mask and then not enforce it. that would be prima facie evidence of a breach of the duty of care. So the breach of that duty would be somebody's failure to wear a mask, and especially the failure to enforce the mask requirement against probably your recalcitrant boarder who thinks that because they're paying $700 a month, they're entitled to not follow the rules. The causal connection would be, let's say that a student becomes ill with COVID and is somehow able to demonstrate that that particular boarder's failure to wear a mask resulted in that particular student's COVID infection. The odds against that are pretty significant, but for purposes of today, that's going to be the example that I'm using. The loss would be that the student becomes ill, incurs medical costs, and sustains lasting damage to health. The other element in Maryland only is that the student was free of contributory negligence. So if that student also failed to wear a mask and interacted with that boarder without wearing a mask, then that is contributory negligence. And no matter how bad her injury, her illness is, she would not be able to sustain a case in a court of law. Please be conservative. Don't push the boundaries. I know that people like to come up with ideas. Well, for example, the governor's order says it's okay to render animal care during the stay-at-home order. And it's important to my horse's well-being that he be kept in training so I can maintain my training schedule and still be in conformity with the law. That's not it. Don't push the boundaries. Be conservative. I recommend that barns establish a set of COVID rules, post them in the barn or wherever the place is that you communicate with your people. I further recommend that they be printed and given to everyone, and that everyone has to sign an acknowledgement that they have received those rules. And the last thing is simply to enforce all those rules and policies. For example, there's absolutely no point in your having sanitizing dispensers if you don't keep them filled. That again would be prima facie evidence of negligence. So just to reiterate, in any fact pattern that you are facing, any question that you have where you're concerned about negligence, ask, what is my duty of reasonable care? What standard of care do I have to follow? Am I failing to conform to the required standards? I hope the answer is no. There has to be a close causal connection between the failure and the resulting injury, an actual loss or damage to the interests of another, and no contributory negligence by that other person. So that's the overview of negligence, and later on in the presentation, we are going to answer some specific questions where we will be applying those concepts to find the answer. So thank you, that's all I have for today.
Well, thank you, Kate. And like I said, I did my best to sort of post your bullet points in the chat box as you were going. Not perfect, but we will certainly get everyone a copy of it as well afterwards, and everyone will also have a chance to ask questions on the follow-up. Okay, so not perfect, but we're making it work. So we appreciate everybody's patience this morning. All right, so let me get up next. We have Andy. Here we go. So Andy's up next, and he is from the Piedmont Group Insurance Solutions, and he has been working with agricultural entrepreneurs to design custom risk management programs for 20 years. You don't look that old. So he will talk about a couple of insurance related topics, I know we're moving a little bit ahead, but CR is also going to be an insurance expert. So the last two panelists will be focusing on more specific insurance questions. And Andy, I will let you take it away.
Thank you, Corinne. Good morning, everybody. And thank you, Kate, for those initial words. That was excellent. I don't know if any of you on here today are like many of my clients over the last 10 weeks, but I've never had so many people reading insurance policies as I have for the last 10 weeks. Lots of questions have been been thrown our way since the middle of March, and our position has been one of just kind of trying to hold people's hands throughout this. It's important for people to understand that the insurance industry has modeled for pandemics like this for decades, which is the reason why there's no coverage for any of these kinds of things. The industry, tried to extrapolate premiums over top of the exposure, and they've never found a way, an affordable way to charge for something like this where they could step in and start to pay claims. So many of you have probably heard the word no quite a bit if you've had conversations with your agent or your broker lately. Lots of folks are digging in and finding or terms like civil authority, business interruption, business income, extra expense, those types of, that type of verbiage in the contracts. Unfortunately, it does not relate to this. One thing you can know, I think pretty definitively, is that there's no coverage for something like this as of now. That doesn't mean that someone's not working on it, and when they do, as an insurance professional, we'll review the contract, we'll review the coverage forms and see if that's something that's worth taking out to our clientele. But this, again, just back to exclusions. If anybody ever has picked up an insurance policy, there's 3 or 4 pages of what an insurance company covers and then 90 pages of what they don't, right? That's kind of what everybody knows about insurance companies. So like I said, they've modeled this for years. And so communicable disease, viruses, all those things have been excluded up until now. If and when they do come to market, that will be vetted thoroughly by people like myself and CR, and we'll see if it's worth taking out to you folks. There's a little bit of a conspiracy theorist in me in that there is a civil authority clause in contracts, and that there's a reason why martial law was never enacted with this. Had an insurance company, just one insurance company, had to come out and pay a claim for something like this, it may have set a precedent, meaning all insurance companies may have. So understand a little bit that had these insurance companies had to step in and pay business interruption claims to the tune of millions, if not hundreds of millions or billions of dollars in lost revenue, there wouldn't be an insurance industry around after that. So, this is part of an educational piece that we try and talk to folks about, to say, going forward, we'll hold your hand through this, but up until now, there's been no coverage. My crystal ball tells me a little bit that moving forward, using 9/11 as a basis, with which to have this thought, after 9/11, every insurance policy that gets sold, typically a few pennies of those insurance policies goes into a pot for TRIA, the Terrorism Risk Insurance Act. Should there ever be another terrorist act on U.S. soil, there are dollars in a coffer to come and pay those types of claims going forward. So my crystal ball tells me that maybe there may be a PRIA type coffer or fund going forward, where I'm calling it the Pandemic Risk Insurance Act or something like that, that may step in and help to pay for lost revenue, something of that nature. But again, we consider ourselves a resource for folks like yourselves. Use us. We try and create some predictability at a time when there is no predictability to some degree. So we try and assist folks like yourselves with mindset. 3 questions we ask a lot right now are, what's going well in your operation? Focus on that, build from that. What's been tricky for you? How can we help maybe maneuver or navigate through those waters? And what's something that you're doing differently now? Life is a lot different than it was, 60, 70, 90 days ago. contact your agent. Talk to them about your work comp policies. If you have one employee, you should have a work comp policy in place. Payroll, a lot of these policies are based on payroll or sales. I venture to say probably a lot of sales are down right now. Payroll is probably down. These policies use those two factors as a basis with which to charge premium. Work comp is its own animal. If you have a work comp policy, it operates on an annual basis. So you have to contact your agent and say, you know, we're 2 or 3 months into this thing. I don't see an end to it as far as where my payroll is headed. We might want to make an adjustment, but that adjustment will be made on an annual basis. So understand that if you reduce those payroll figures now and you get to the end at audit, and assuming payrolls did stay down, you should be fine. But if for some reason you ramp back up in the fall or whatever it may be, and your payroll goes back through the roof and you've changed it, you could get hit with a big bill at the end of this thing too. So we can help maneuver through those waters or navigate through those waters, but just understand that if you're paying less now, you could later. Autos, for instance, some autos are based on radius classes and or mileage. And so if you're driving less or you're not driving as far, talk to your agent about those things. That could be another way to put some more dollars in your pocket. Be mindful that if you do have employees and you're an operation under 500 employees, you are still held to the broadening of FMLA, the Family Medical Leave Act now. Had the coverage for that now has been broadened to anyone who has an employee, one employee or more. And what that says is you can't fire someone if they have someone who's sick at home or they have children at home who aren't going to school and they have to stay home and care for them. You are being held to the same standard as a large employer now. So be mindful of that. The employment practices liability exposure that you have now that you may not have thought about. So be mindful of that. The Department of Labor came out with their revised enforcement policies. I think I don't know if it's been sent to everybody here, but they have.
It will be forwarded with the materials afterwards, the 2 documents that you provided.
Great.
Okay.
So that's a great document to make sure that you are apprised that OSHA is ramping up their in-person inspections of all types of workplaces. It doesn't matter what type of workplace you are. They are ramping up. And non-critical businesses, as you start to reopen, are subject to those inspections. And then secondly, they are revising their previous enforcement policy for recording cases of viruses, or in this case, coronavirus. It is now considered a recordable illness, and you are subject to adhering to the rules and regs of that. And so I put out another piece of that yesterday, so you'll get a copy of that as well. The other piece I put out was the Department of Labor's guidance on preparing your workplace for COVID-19. It's a lovely, like 40-page doc that you can get 3 pages in and fall right asleep. It's a great piece to take a nap to. But use folks like us. That's what we're here for, is to kind of navigate those waters. Like I said, I'm here the rest of the seminar, but that's kind of the skinny on what I wanted to get out to you today.
Well, that's great. Thank you, Andy. And the 2 documents that he mentioned, we will forward to all the registrants after, as well as Kate's presentation and the agenda again after the seminar is concluded. All right. So next up, let me switch screens here, is CR. Oop. Okay, Bogendorf, and welcome. And CR has, well, it doesn't say you've been doing this for quite some time, but you're licensed in 6 states. But ultimately, what I find way more interesting is the fact that you're a 3-time National Reining Horse Association world champion.
Yes, ma'am.
So was that on the same horse?
No, 3 different horses.
Oh my, okay. That's even a bigger accomplishment. Congratulations. I think that's just fabulous. I think you should have those awards in your background there.
I should.
So that's fabulous. And also, as an aside, since you were past president and past vice president of the National Reining Horse Association, have they put out any guidelines that you're aware of in terms of how to address some of these COVID in terms of safety?
Not that I'm aware of for what they've put out.
Not yet? Is that what you
No,
said?
I haven't received anything through email from them regarding that.
Okay. I'm assuming a lot of these things will come out. I just thought I would ask since I
Yeah,
know they are.
it's been some time before I was that involved with it, so I'm not number one on their mailing list anymore.
Well, you should be. Well, in any case, I figure you're our connection there if you hear anything. And of course, you're a Farm Bureau member, a Forest Council member, and all that, which is great. So, bottom line, a lot of equine experience and insurance experience. So we look forward to your brief presentation, and he will also be available, as well as Andy and Kate, for questions afterwards. Go ahead.
Perfect. Well, thank you for that. Good morning, everybody. As Andy previously mentioned, I'm not going to repeat a lot of what he said, but everything that he said was very, very important and great points. I do want to talk a little bit more about the midterm policy adjustments. If you're not working to your normal capacity, make sure you are talking to your agent because, like Andy said, you can make adjustments, which can help everybody out. Moving from that, a lot of what's going to protect you from an insurance standpoint, the expression common sense. Let's have some signs posted out. Equine is inherently a dangerous sport. Everybody knows that. But now that we've factored in this whole extra with the COVID and the virus, it's important to just have extra signs out there posted, letting people know they're entering at their own risk. From that, talk to your customers when they come in. Explain to them what you expect from them. The best thing you can do to protect your practice is to get it all out to all your customers. And with that, again, I'm not going to repeat everything that Kate and Andy had already said, but you get the gist. And I'm just reiterating it again because it is very, very important as you move forward. And from that, the key is to be consistent. No favorites. We all have somebody in our barn that we've known for 10, 15 years. They're like family to us. But we got to keep the same rules for one person as we do the new person who you don't know that well. That's how you're going to keep the consistency to best protect yourself. From that, you might want to think about postponing some of your events that you have going on. We have the nice weather starting to come. I know a lot of people, we like to have gatherings at the barn. You might want to think about holding them off or limit the amount of people that can come. And that also includes the amount of people that come for your clients. So if you're giving a riding lesson and let's say Sarah typically brings her mom, her dad, her sisters, and, auntie and uncle, well, you want to limit that. And let's just get mom and dad, the ones that need a driver there for right now, to try and limit the amount of people there. And from that, and this is really important to think about, know your county. Although the governor has the restrictions, counties, the governor has allowed the different counties to kind of make some of their own adjustments as well. For instance, in Baltimore County, where I'm sitting right now, gatherings are still limited to 10 people. So keep that in mind. I'm trying to think, Frederick County, I looked it up yesterday. Andy, you might know, I know you're out there. I believe that's still at 20, but don't hold me to that.
I think it's 20 as well, yes.
Okay. So that's very important as you're thinking about having that, because I know everybody wants to start getting, business rolling again, as we all do. So just keep that in mind. And then go back to communicate with your agent. That's why guys like Andy and I are here. We're here when things go wrong. We're the ones you need to turn to and ask us the questions. I know a lot of my clients call me regularly, and we run scenarios back and forth, and I see quite a few of you here on this call. So make sure you're reaching out to them and have those one-on-one conversations with them, because every operation is unique. Every operation is different. A trainer, just because there's two trainers doesn't mean they run their operation totally different, run their lessons different, run how they handle the barn differently. So make sure you're having that conversation and your agents are there for you. And then, again, I don't want to take up too much time. We'll get to the questions, and then we can continue to answer them for you.
Thank you. That's great. Appreciate that overview. I hope that gave everyone some background to understand the questions that we're going to go through a little bit better. So with that being said, I will turn it over to Carrie and to start with the questions. We had asked folks to submit their questions ahead of time. If you have not been able to do so, Carrie, can they do that in the chat or however you want them to communicate that with you?
Yes, I have the chat window box up. So if you have additional questions for the panelists, you can go ahead and submit them there. And I will start again, but I want to just again, I take complete responsibility for this technological issue here. We tried to use this registration system through Zoom so that we would actually be able to get you very easily a copy of this recording. Didn't quite work as we planned. And unfortunately, in our little pre-15 minutes of trying to cover the tech issues, this did not come up. But let's get started on some of these questions. So the first question we have here, am I covered if someone contracts COVID-19 at my barn? Is there an exclusion for viral contamination to humans as opposed to the horses, such as herpes virus? What's my liability? Does it depend on what the current state of emergency is? These are a lot of questions. Does it depend on whether the person that contracts COVID-19 is a worker or a client? I think that we've got a couple of questions in here that both Andy or CR can answer, as well as Kate. But Kate, do you want to start with some of the liability issues? Yeah.
Okay, well, most of what I heard in that question has to do with the contract of insurance that somebody has. Maybe I missed something, but most of those questions like, where am I covered? Am I covered? You have to read what your insurance policy is, okay, and they provide. But as Andy and CR said, there is no coverage across the board for a pandemic-related loss. So the answer is you're probably not covered. So did I miss something there?
No, I think you did cover it. It did talk about the current state, whether or not this would potentially depend on the current state of emergency as well.
Yeah, so I think on that point, it goes to what Kate said earlier, in that if the law says you shouldn't do it and you do it, it's going to be hard to say that you were following the standards of care. So, you know, as an analogy, if you are driving down the highway at the speed limit and not high on drugs, you're in a better situation to defend a claim if you have an accident than if you are speeding and drinking. So if you follow the law, you will generally be in a better position to defend yourself. Doesn't mean you won't be found liable, but generally better. And Kate, you're the better expert in this, but if I've stated that well enough.
No, you did good, thanks.
That's not bad as a patent attorney. Come on now. I'm an intellectual property attorney, just for disclaimer.
So there's also a question here about an exclusion for viral contamination to humans. Andy or CR, is that something you can?
I can't speak for every insurance contract on the face of the planet, but typical contracts that are sold from admitted carriers in their respective states do have exclusions in them for either communicable disease or viruses, almost exclusively. It's interesting, there are what we call excess surplus type policies out there, what we call Swiss cheese policies, that basically you have to buy in order to make someone happy, whether it's a compliance department or a bank or someone like that. So these kind of the Lloyd's of London type policies get sold sometimes that don't have a lot of exclusions for whatever reason, but they don't have any coverage either. Those are the types of policies that we've seen over the course of the last 3 months now, where there could be some coverage afforded. We're not saying that there is, but because there is a lack of exclusionary language in the contract, that there may actually be coverage afforded because of that. But short of that, I would tell you, in my experience, 98% of the contracts I've seen come across my desk, there is exclusionary language for anything communicable disease or viral related. So most likely there's no coverage that you have inside your contracts.
Great. So I'm going to address this, kind of leads, and I'm going to address the next question here also about coverage to CR. Can I get coverage to protect myself from a COVID-19 outbreak in my barn? if not, how can I protect myself from that liability legally? Can I get a waiver? And that might be a question for Kate too, if there's some type of waiver. CR?
I have to tag team this question a little bit.
Okay.
So to answer your question, as of right now, as we've gone over, the answer is no. There's not a specific policy out there that's going to just cover you for the virus here at this time that I'm aware of. As far as protecting yourself from your overall operation, it goes back to what we've continued to echo here throughout this entire conversation is continue to run your practice as safe as possible. Do all the things that you're supposed to be doing anyway, and following your county and state guidelines.
Great. Do you want Andy add anything else in, or maybe I know there's another question throughout here too about again the waivers we've discussed, but maybe Kate addressing any type of special waiver release form they might be able to use at a boarding barn.
If you're already using a Masterton release, you're already covered. But if you're not, excuse me, certainly you can ask for a waiver. Now, the one thing I need to say here, I always hear, and I'm seeing in the chat, people are saying, can I be sued for? Can I be sued for? In America, anybody can sue anybody for anything. So the answer is always yes, you can be sued, and it'll be a pain in the butt, and you have to pay an attorney and so forth. So releases are good, waivers are good, but at the end of the day, you can still be sued, and you can still have that cost and attorney's fees. In my opinion, when you have losses that can be covered by insurance, one of the best attributes of the insurance policy is that the insurance company puts on the defense. They pay the attorney. Believe me, that is a really good thing to have happen. The way to prevent people from suing you, I think, is to be nice. They've done a lot of statistics on attorneys getting sued, and it tends to be that attorneys who are kind and caring and who return calls promptly, things like that don't get sued as much. And the ones that are abrupt and unlikable and so on tend to get sued more. So I know this may sound a little bit Pollyanna-ish, but try to be a good person and try to always do the right thing. And I think that is equally, if not more, as important as having waivers.
That is excellent advice.
So next question here, again, might be for Andy and CR. Am I covered for the loss of business income? Is there an exclusion because there hasn't been any property damage if the roof blows off the arena, et cetera? I am covered, but maybe not without property damage. How will this affect my taxes, payroll, workers' comp, et cetera? Again, might be a two-part question.
I can jump in if you'd like.
Likely dependent on coverage.
Again, for any of those triggers for business income, extra expense, business interruption, there has to be a loss to the property itself. It has to, that's the cause of loss there. Couple things to that. If there were a civil authority clause or a martial law type situation where you were not allowed back into your barn for some reason and there was a loss because of that, that would be a trigger. But short of that, no, there's just no coverage for it. How will this affect my taxes? I can tell you we are advising our clientele that if you do sustain some losses or some a serious negative downturn, contact your CPA, contact your accountant. Any losses can be carried over onto your balance sheet or your P&L there. If you sustain losses, work with your CPA, give them a call immediately. We're doing a lot of that between the CPA, ourselves, and the client over the last few weeks. But short of there being some physical damage to your property, There is no trigger for business income, extra expense, business interruption, that type of thing.
So again, next question again, I think is another variation of what you've kind of answered in the past. Am I covered for anything, injury, property damage, loss of business during the state of emergency, or is there some sort of act of God exclusion for, I suppose, this novel virus? No, I was going to say, I think that this has pretty much been covered.
The same question.
Okay. Next question. This is again one a little bit more particular, but one we've certainly had over the course of the last couple of months during this crisis. Am I covered if I get sued for closing my barn and preventing boarders from, and this might be directed towards Kate, covered if I get sued for closing my barn and preventing boarders from seeing their horses? What if a horse gets hurt because it cannot be turned out or exercised by its owner as it used to be?
Okay, so taking the first one, where you have to close your barn and not allow people in, can you be sued for that? Yes. In America, anybody can sue anybody for anything. If you are sued for it, will your attorney be able adequately to defend you? Yes, because you were following the law, and because the law required you to act as you did, it's not negligence, and you probably would be able to defend it, even if it's a breach of contract claim. You know, oh, I paid you for board and the use of the indoor, and I wasn't allowed to use the indoor, so I'm suing you for that $500 of board this month. Well, you know, I cannot see any judge in the state of Maryland allowing such a claim to go forward if the law in place at the time the incident occurred required you to close the barn. So, and what was the second part of that question, Carrie?
The second part was, what if a horse gets hurt because it cannot be turned out or exercised by its owner as it used to be?
Okay, so that's a question of negligence, all right? So if in that instance, you would have the owner saying, I think that you were negligent in failing to allow my horse the required activity, and so I'm suing you. So look at it. What was the duty to use reasonable care? Did the operator still have a duty to turn that horse out in a pasture despite the COVID? Probably, yeah, because even at its most restrictive in the state of Maryland, animal care, the provision of animal care was permitted, and employees providing animal care should continue to do as they are, as they typically would. Was there anything else I missed in that question?
No, but the part two, or the next question, is sort of an additional question on top of that, that asks again about essentially if they're covered or if you could potentially be sued. If a boarder or a horse gets hurt once the barn reopens on that first ride post-closure, how can I protect myself? Will I more or less be liable if I impose more restrictions, more or less restrictions? More liability usually follows more control. So after, since we have sort of reopened.
I'm not really sure how someone getting injured on the first day of reopening would be any different than someone getting injured on any other day. You go back again to my outline in determining what constitutes a claim for negligence. Who had the duty of care? What was standard of care, et cetera, et cetera. How can you protect yourself? I think we're sort of going over the same territory here. You can protect yourself, first of all, by having a talent for client selection. Again, this is not legal advice, but troublesome boarders will always be trouble. Troublesome students or troublesome parents will always be trouble. And after a while, you need to realize that the revenue you get from it isn't worth the hassle and the potential for litigation that would always be hanging out there with someone like that. So choose with care who you do business with. Have very good documents and a very good release in place. And this applies across the board. I need you to understand that COVID, in terms of negligence, is no different than any other run-of-the-mill issue that a barn operator will face. How can you protect yourself? What are some of the things you should be doing? I'm looking in the chat room, and someone is talking about face masks. So let me go back to that issue for a moment. Face masks are required when you are less than 6 feet away from somebody. And that's true whether it's inside or outside. Go to the CDC page, read what they say. Don't listen to politicians, protesters, pundits. And don't try to push the envelope. I'm looking in the chat room and they're saying, well, what if you have the barn windows open? What if the doors on the indoor and outdoor are open? Isn't that not an enclosed space? Why do you even want to split hairs? Require a mask. Make them follow the rule that you require the mask. And if anybody catches COVID, you say, hey, we don't have to split hairs as to whether or not there was sufficient circulation in the barn. I said they had to wear masks. That was the law. They wear masks. That's my defense. I think that's a pretty good example of how you can protect yourself. Don't try to be a hero. Don't fight what the law says, no matter how much you disagree with it, how uncomfortable it is, how many people grumble, just do it.
Thank you. So the next question here, actually, again, I think it's going to be more directed to CR and Andy. How does workers' compensation coverage interface with other liability coverage if an employee contracts COVID-19 at the barn?
That goes back to one of Kate's comments also about, can you prove it? If you have an employee that has children at home, has other employees there, it has to be proven that it was contracted there. Anybody can sue anybody for anything, as she's mentioned. But putting the processes and the systems in place, you can't over-document these situations, I think, is what I want you to take away from this today. That the better prepared you are from a posting of signs, having the systems, the proper releases, all these things, whether it is someone who is there as a boarder or whether it's an employee, that is paramount. And that goes to this information I put out from the Department of Labor also on, most folks here, I'm assuming, will be considered, I think they do it as small, medium, and high risk. Hold on one second. I believe that's how it's listed. So everyone's going to be, low, medium, and high. So everyone here is considered, the job classification will be considered lower exposure risk, I believe. I'm guessing. But the first thing OSHA says is you have to develop policies and procedures for prompt identification and isolation of sick people if appropriate. So you have to have all these things. As a business owner, you have to put this stuff together. Kate mentioned the word invitee. The minute you invite someone on, and there's been, whether it's remuneration or consideration, once that takes place and you're taking $1 from someone, you have to adhere to all these guidelines and these rules. Like I said, this stuff's an easy way to take a nap, but you better at least start reading it and being apprised of it. But up until now, workers' comp has not covered things like this, but they do have these revised guidelines that are out now. So it does not hurt to try and abide by them sooner rather than later.
There was a question that just came in the chat. Yes, after the webinar here, the seminar will send out the OSHA PDF that Andy had provided and a press release, a news release. Yes, that news release, which I think was dated the 19th. Okay, we have a few more pre-submitted questions, and I think we have, Kate, you've done a great job of actually looking in the chat window and addressing some questions. There is one still in there that I do want to address because I know it's come up multiple times. Again, last couple of questions here go back to this special waiver release form, and then incorporating, and I think this is just reiterating again, incorporating a communicable disease such as COVID-19 into established participant liability release form. I think even Andy just said it's not the over documenting things. If you just want to reiterate what you've said before, maybe briefly here, and then we'll move on to the last question we've had in the chat box.
I'll hit on something real quick that was in that press release from last week on the revised enforcement policies. Employers with 10 or fewer employees and certain employers in low hazard industries have no recording obligations. They need only report work-related coronavirus illnesses that result in a fatality or an employee's inpatient hospitalization, amputation, or loss of an eye. So if you have less than 10 employees, you don't have to, but it ain't going to hurt you.
No.
It is absolutely recommended that you document as much as you can, that you're trying to create as safe a work environment for your employee or employees as possible on a daily basis. But this is, it's really good stuff. So I highly advise you to jump into that. And it's inside of that page, there's a bunch of hyperlinks to different parts of OSHA's revised guidelines that you can kind of extrapolate and put into your own practice.
Great. So Corinne actually just typed in here the question from Ann at Holly Ridge. Her question is really about co-insurance and the subordination of claim, where one insurance company tries to go after another party's insurance company if they are somehow connected to the claim, or potentially to sue the other party for being the cause of the accident or injury. Corinne, I don't know if you want to elaborate on that.
Well, this is a question that Jane got, and I'm not sure if she's able to get on to elaborate. I took that from her email. I pasted it exactly as I saw it, so I don't.
Okay.
Does that make sense to you guys, or sufficient to address? Or we can see if we can find Jane. I know she's on, but I don't know which one she is.
She's on via phone. Let me just check her number.
I don't know if we're talking.
Can you guys hear me?
Yes.
Oh, there you go. Go ahead.
I think Anne from Holly Ridge said she was going to be on the call, so she can maybe explain more. But I don't really think this question is actually related to COVID. It was brought up by, I believe, someone she knows who got a letter from an insurance company asking for more information about a claim for an accident or injury. And I think it was related to trying to track down whether there was another party that could be held responsible for the accident or injury. But if Anne is on the call, she could probably explain more. It's not my understanding that it's actually a COVID.
Yes, Anne, we can hear you.
Hi there. It is not COVID related. It is horse related. The situation arose where a child got hurt riding, had signed the liability release, etc. Parents had no problem with what happened. Many months later, the parents get a letter basically saying that they'd like more information because they'd like to sort of put a net out there to see if more people could be responsible that they could go after to sue in order to compensate Blue Cross Blue Shield. So the question is, how does that affect stable operators in that situation?
I'll take that.
Okay, go for it.
Okay.
This comes down to risk transference and having solid waivers and documentation in place. Back to what Kate mentioned. If all this is done on the front end correctly, this is all moot. Um, we see this a lot where there wasn't coverage in place and someone starts sniffing around trying to find it. Somebody needs to pay the bill and it ain't going to be me, so let's figure out who can. And if the proper risk transference conversations have been held and followed through with, typically becomes moot. But we see this quite a bit in this industry because proper conversations have not been had. So in this situation, I can't speak to it directly, but it sounds like that wasn't done. That's my inclination to that.
Okay, so I'm going to ask this final question, which I know has been addressed before, but I think it just bears reiterating again since it's something that keeps coming up. And then I'll ask all three of you to provide kind of some closing thoughts of just the most important takeaways from today. The question is again about having a separate release for COVID-19 versus just a release for all other illnesses that they may have currently.
Well, if your current release form specifically includes biohazards, then you're already covered. It really depends on the wording of your release form, whether it specifically covers the COVID. You should certainly be reviewing your release form or maybe having an attorney review the release form and see if it needs to be updated. Question, is there any harm to having it? There could be if it's not worded properly. Remember earlier I said that it's better to, if you're not going to enforce the rule, then it's probably not a good idea to actually have the rule because that would be evidence against you if you should be sued. So I've never actually had to think about that, whether there's actually a downside to having a release that specifically addresses COVID. But look, as a practical matter, you can't foresee things like COVID, and I don't necessarily think it's a good idea to start parsing out, have a release for this risk and a release for that risk. I think risk management has to be an overall policy at every barn, and a well thought out, well drafted release form is a part of that. And so update your releases now, and you won't have to worry about this, that, you know, the next time something goes around.
And just a clarification here, there's a question again from the same farm. The difference, is there a legal difference between illness and biohazard in this circumstance?
A biohazard can give rise to an illness. Biohazards are the agents of illness. And so if you have a release for all the risks of biohazards, a consequence of a biohazard is the illness. And in my opinion, I'm not the law, but in my opinion, it would provide a very good defense in that case.
And just to reiterate and to follow up on what Kate said in terms of general versus specific, since I'm, as a patent attorney and as a chemist, you know, COVID is a particular SARS virus. And if you only have a release for COVID-19 and we end up with COVID 2020, you won't be covered. And so therefore, the type of language that Kate is talking about would, in my opinion, probably be more beneficial to cover you in the future. And rather than have an addendum to your agreement, I mean, Kate, you can tell me, but what I've asked my boarders to do is a condition of coming back to my barn is their agreement to sign an updated boarding agreement, which has an updated language to cover some of these eventualities that we had not thought about when we set up the barn in 2001. So that would be my suggestion. And Kate, of course, you know, you can let me know what your thoughts are, but you know, when in doubt, do it. There's just no reason not to. And, you know, you can take as much risk as you want, but then that just might yield certain consequences.
I endorse everything you said.
Great. So last question here that I'm sorry, this was going to be my last question. And it's something, again, that multiple stables and facilities have had, and it's also a question when we ultimately will talk about competitions and events at some point in the future. Any decisions concerning the number of gatherings allowed in equestrian facility. In this particular situation, it's a larger property, and they're looking to conduct activities outside in certain areas of the property, but there will likely be more than 10 people on the property at one time. But conduct activities where people are socially distanced to 6 feet apart, and have more than 10 people at a time on a larger property.
Okay, this actually is a really good question, because having read all of the interpretive guidance that's out there, I see nothing that sheds light on what is the legal definition of a gathering. So then I'm left with the common sense definition of what is a gathering. And my Webster's dictionary says it's an assembly of people. So I think, and when you can't find a definition, you have to look at what is the policy that's sought to be effectuated by an otherwise ambiguous law. So the policy is to prevent the transmission of the illness. In my opinion, I think a gathering is an assembly of people in more or less the same place, which doesn't mean premises. So if you have 9 students and an instructor in one riding ring, that I think is a gathering. If in another riding ring on the other side of the barn, you also have a lesson going on, I think that you have 2 separate gatherings. Again, my opinion, that's how I would write my brief if I were trying to persuade a judge that it was okay. Always think what conduct of mine will best effectuate the law. And if it's gatherings of 10 people, okay, I'm not going to do it. They won't all be in one place, but spread out where the transmission of the illness is not going to be possible. That's something different.
Great. This is actually sort of a great follow-up and caveat to that question. The orders allow businesses to operate at 50% capacity. I still believe the gathering is in the last executive order is also in place. But
Yes.
Does that, if you want to address how does that apply to gathering then, if businesses can operate at 50% capacity?
So I guess the question is does the 50% trump the gathering limitations?
I have to say I haven't focused on that aspect of the governor's orders. In my county, we are still operating under the old rules, so I haven't had occasion to really focus on that. My sense is that it was addressed to businesses within some kind of an enclosure, offices, factories, certainly retail stores. It actually has not occurred to me that it would extend to agricultural operations.
If I can just jump in, this is Jane. I believe that the governor's orders, when they refer to 50% capacity, that number was used only in very specific stated cases, like indoor religious gatherings, but it does not apply across the board to all businesses. I think that in general, the 10 person in a gathering rule still applies, except in those very limited and specific cases where the governor said 50%. And I think that, for example, what he said yesterday with regard to pools, public pools, he said 25%. So I think you have to look at the specific circumstance if you're trying to look at those numbers. And I think that I agree with Kate that it doesn't apply in agricultural, or at least I have not seen anything that would indicate that it applies in an agricultural context.
Great. So since we're running over time already, I think we've addressed all the questions that have come in through chat. You can always direct questions back to the Horse Council. And again, we'll provide in that additional email afterwards contact information for all.
Carrie, can you hear me?
Oh,
This
yes,
is
I
Neil.
can hear you, Neil.
Sorry, I did have a question, but you guys all answered it so well. So I wanted to just jump in before we finished and thank everyone for their participation, especially our speakers and also our legislative committee who put this together. Carrie, Jane, Crystal, and Corinne primarily, but all the folks on the legislative committee. I think it was, as I say, I had a couple of questions, but they all got answered, and I'm very impressed that I've been able to stay online through Pennsylvania and Ohio, but I want to thank everyone for joining today.
Great.
And I wanted to also to reiterate on what Crystal said earlier, is that anyone who has participated and who is not a member, we would encourage you to become a member. We'd like to be able to continue to offer these types of seminars and town halls, but we really need your support. So we encourage everyone to renew when the time comes, and hopefully also to join if you're not a member currently. If you have any questions about the Horse Council, feel free to reach out to Carrie or Neil. Crystal, is that about it? I mean, definitely would love to see everyone support what we're doing here, and hopefully you found this town hall helpful and informative, and you'd like to see more of them. So, you know, we need support of our members to do that. Thanks.
Yes. And I'm going to ask, because I had asked each of the presenters, if you just want to follow up with one kind of final wrap-up point, something that you really want to make sure everyone takes home. And then, again, thank you all for joining us. Andy, do you want to start?
Sure. My gut answer is just to say, kind of piggyback on Kate said, be nice to people. It's the golden rule thing. You are in business. You're inviting these people onto your premises. Do the right thing. Be as good a business as you can, and then this is a who not how situation. Who do you know that's best in these areas that you can kind of pick their brains? Use these folks on the panel here, your CPAs, that kind of thing. Who not how is what I would tell you to take away.
Great. CR, do you want to just give one final thought for the day?
Sure. Again, thank you for having us. Please, anybody with anything, just know that you have resources. We're here, eager to help if you need anything. Feel free to email us any questions we might not have gotten to, and I'm sure anybody on this panel here will be willing to answer them for you.
Wonderful. Thank you. And Kate?
I think I'll leave you with the idea that we need to have a healthy perspective on this. I mean, COVID seems different in so many ways, but from a legal and a risk context, it's really not different. Manage all of your risks properly, and COVID will simply follow its own place. Don't focus on it. Don't cut corners. Be conservative. And that's it.
Wonderful. Well, thank you again, all of our presenters, and for joining us here this morning and this afternoon. And again, that follow-up email will go out this afternoon to everyone who had registered for the event. So thank you again. We certainly appreciate it. Thank you.
Thank you.